Looks like things have slowed down. Chelsea, are we where we are?
You weren't coming in.
Okay. Okay, well, I'll get started on the basic stuff while the last few people get in. I'm Lisa McMahon. I'm one of the associate attorneys at Condominium Law Group, and I'm here with Ken Hare to discuss today's topics. Just a few reminders. I'll go very briefly that this is general information. It is not legal advice, any of the questions that we answer today. Please try to stay muted. It helps us so we don't hear a lot of distractions in the background. And if you have questions or follow-up, go ahead and put them in the chat and we will try to get to them at the end. We do have a lot of questions today, so we may or may not be able to get to additional questions, but we'll do our best. Okay, without further ado, I'll go to question 1. There was an Airbnb found in an HOA, and the board has said that if the homeowner wants to continue, then they will have to modify their listing to be a 30-day plus rental, and a lease agreement needs to be submitted with an ARC every time the rental is used. The requirement of an ARC makes me think that this is a board approval attached to this process. Is the board overreaching, and what limits does the board have overseeing rentals in a community? I think the short answer is if the association does have rental restrictions and a lease needs to be reviewed every time a new tenant comes into the property, and that happens every 30 days, then the answer is yes, they do have to review the lease every time a new tenant moves in. And if the CC&Rs or any amendments to those CC&Rs have a minimum amount of rental days, so if it's 30-day minimum for those rentals, and the listing says it's 30 days, there's no violation of that rental requirement. The board appears to be enforcing the rules strictly, and that's appropriate in this situation. I don't think they're overreaching, but you'd have to look, of course, to the documents of this particular association. You'd have to look and see whether or not what the requirements or what the rental restriction is in their governing documents or any amendments to that. If there's specific questions about that, I would certainly talk to association counsel, because there may be something that's not apparent to us in this question. Ken, did I miss anything there? Anything you want to add?
Well, I would just offer that it also depends on whether you are enforcing the same provisions against every owner.
Right.
So if you were trying to punish this owner because they're doing 30-day rentals by putting them through an arduous review process, but you're not doing that for the people who are doing 6-month or 1-year rentals, then that's going to cause problems. So question 2 is, we are a Ukiah association, and it states that except as provided otherwise, the board must be comprised of at least 3 members, and at least a majority of whom must be unit owners. My question is, can an association restrict membership on the board to only owners if both the bylaws and CC&R stipulate this, or are they obligated to allow non-members based on the language of the statute? So I guess first I would say I want to make sure you're defining owner properly. The statute also discusses that for purposes of serving on the board, you are allowing people who are technically not legal owners, like representatives of corporations, trustees for trusts, partners and partnerships. Those are not the owner of record, but they are the people who are allowed to serve on the board under the terms of that statute. And so if you're trying to count those related people as non-owners, then they have to be allowed to serve. If you're just asking, are you required to allow some other completely non-owner on the board? My answer is no. If the governing documents say 100% have to be owners, that meets the statutory minimum of a majority or 2/3 being owners. And so you can have restrictions on ownership for service on the board. Did I get everything in, Lisa?
I think so. Yeah, I don't see anything else.
Okay.
Okay, next question. Please share about photo documentation of violations. In our community, any owner or occupant can submit a violation, and we encourage photo documentation, yet we want to respect the right to privacy. It's not the question is hard to find in here, but I think the question is it a problem? Is it against someone's privacy to send in a photo? And the answer is no. You don't have a reasonable expectation of privacy if you're outside of your home. And photographs can be great evidence of a violation. Be careful to make sure that it's not been photoshopped or altered in any way. But it could be, be very helpful to a board or to a manager to know that whether or not they need to inquire as to whether or not there is a violation. I don't think, if you're thinking about the right to privacy, but going back to that question, I don't think we usually see an issue with a photo documentation of mold on a roof or an unkempt lawn or something like that, violating anyone's privacy. As I said, being outside or taking photos of the outside of someone's residence is not violating their right to, reasonable expectation of privacy. I don't think anything else, Ken, that I missed on that one.
No, the only example I have is that we had actually, I think it was a court case where photographs were submitted by one owner of a neighbor's trees blocking views, and the photographs did not accurately represent the view blockage. It was basically manipulated by the owner taking pictures from a location or from a lower standing point. So a photograph by itself is not always going to be enough information for the board to meet their duty of care of inquiry and use of objective information in finding a violation. So next question is, the board wants to be notified when there is an after-hours emergency prior to services being engaged. What rights do boards have to access units prior to services being engaged? So I'm not clear whether this question is about the manager's authority to hire vendors before the board knows what's going on, or whether it's about the board's right to get in and see if a damage or broken water pipe is really broken before a plumber is called. So this is one that really needs a lot of, I'll say, facts or context for me to give specific legal advice. More generally, I would say that sure, boards have a right and a maybe even an obligation to know that work that's being performed by the association is necessary. And so I would normally say, sure, the board has the right to look at the repairs that are needed and make a decision about the vendor, even in an emergency. But what I don't want to do is set up a process where you've got a frozen fire sprinkler line and no one comes out to fix it because the board members aren't answering their phone at 3 a.m. to go and authorize the contractor, especially if you've got a management contract in place, which has given authority to the manager to make certain kinds of decisions. So there's a lot I don't know about what's causing this question. And I'd want to get more information to give any legal advice. Lisa?
Yeah, I don't think I have anything further. I was just going to say, yeah, it sounds like there may be a conflict between the board and the manager about when things are ordered or requested. The next question. We are an association community that does all meetings on Zoom. When it comes to electronic voting, is there a certified, legit software program that the managing company should be using for electronic voting to elect board members at their annual meeting? Or can they just use Zoom voting or software? Last year we did electronic voting and none of the homeowners got an email stating who they voted for. The manager just rambled the number of votes with each candidate and announced the winners. If we have an elections committee, can't they see the electronic votes and who everyone voted for? Just make sure someone didn't vote twice, et cetera, et cetera. The short answer is that there are a lot of voting software programs out there, and we don't endorse any, and I don't think there's any particular certification program to determine which ones are legit or not. We did talk about electronic voting, I think in last week's Zoom. So if you have more questions about, I think the more technical side of that, go ahead and look there. It may or may not be reasonable to have voting done on Zoom, depending on the size of your association. If you've got 5 units, it might make sense if you can just show a raise of hands or to vote and have the manager or the secretary take record of that. If you have ownership percentages that are different and have different voting power, you have to have a system that can accommodate that. And as Ken pointed out, we were talking that isn't something Zoom can do unless I suppose you had a tally sheet, but that seems overly complicated. But in any event, we don't have a specific recommendation. You can certainly look, I know that the CAI message board has had lots of conversations about association voting, electronic voting programs that can be used. So you might be able to find more information there. But generally speaking, the legislature hasn't addressed electronic voting. And no one's authorized or approved any specific programs. We talked a little bit about, I think a couple weeks ago, that the statutes, the updates to the statute, the record statutes do require that, ballots be kept for a year and that owners have a right to review them, but they have not addressed whether you have the right to review records, including the ballots, to verify who voted for, or to confirm the votes counted. And there isn't any discussion of that in the statute, and they haven't talked about electronic voting at all, which seems a little bit behind with all the other electronic stuff that's come out in the past couple of years with Zoom meetings and things like that. It would be useful information to have. We had another question that sort of combined this issue, and I think we had talked about this again, and Ken, you wanted to talk a little bit about the absentee process and some other things related to that.
Sure. So the legislature has not addressed anything to do with a right to secret ballots, which a lot of people assume exists. And so we have a lot of clients that are trying to protect the ballots and not let their neighbors know who voted for who. And this is an American tradition to have secret ballots, but there's nothing in the statutes that provide for them. And you have this conflict between trying to preserve secret ballots and yet meet the requirements for record review, which are pretty clearly stated in our new statutes as of July of 2023. And the other thing which I would always ask when someone starts discussing this with me is, well, what difference does it make if if a ballot is miscounted or you can't verify? I find it interesting that the legislature listed that if the association uses absentee ballots, that they must have the ability to confirm that the ballot was cast by the owner. But there's nothing else about confirming ballots cast for elections or for votes taken in any other way. And the same requirement doesn't apply to proxies, it just applies to absentee ballots. But if it's not a closely contested election, it may not matter. So if someone came to me and said that the balloting process was not done properly, or the electronic voting was done improperly, and it was to ratify a budget and they didn't have a quorum for the meeting, then my answer is going to be, it doesn't matter at all. You can't use that procedural error to invalidate the results. And if you were going to start trying to use procedural errors like no one got a text message telling them that their vote had been counted, I would start looking at, well, what's the result that you're trying to challenge and why, and is it going to make a difference? And I had in the last couple of years some elections which were incredibly close, and we had one even where every ballot for a revote was sent to 2 different law firms to confirm, and then the two law firms had to compare to make sure that their spreadsheets matched, and the spreadsheets didn't match, and there was a difference of 2 votes, and so people were still upset. But if you think there should be a right to secret ballots, then you can certainly talk to your legislature. My response to a lot of clients is, can they vote over Zoom? Is if you do a roll call vote over Zoom, I think that there is no way it's going to be successfully challenged, because you've got everybody voting in real time and everyone gets to hear everybody's vote. And so if you're concerned about that, then, get rid of this notion that you get secret ballots and hold your vote openly. And that's the way to solve the problem. Anything else, Lisa?
No, I think you touched on it, but the part of the question was that they didn't get a notification back about their vote. And as you pointed out previously, that there is no requirement to get a receipt or any bounce back confirming your vote. And so you're probably not gonna get that.
But there should be a tally sheet which actually could be reviewed after
That's
the
right.
fact to confirm that everyone's vote was taken.
That's right.
I think it's your turn.
I think that one was me, so but we're going now off number, so you're number 7.
Okay. Has CLG ever experienced recommending rules regarding gas fire pits on condo decks or patios? Have they been allowed elsewhere? Have other associations set rules or requirements for homeowners? Well, the short answer is yes. We've worked with clients before on fire pits, smokers, and barbecues. And, for the most part, associations have the authority to regulate the use of the limited common elements. And so it's something that we can certainly help with, and you can regulate if you want to. Anything else?
I don't think so. Next question. If a condo association needs to make major repairs on a building, is the association responsible for housing displaced residents during repairs? The short answer is almost always no. To this question. Most repairs don't require displacement of owners. And most governing documents specifically limit an association's liability to the repair or the replacement of those common or even unit components, but they don't usually extend coverage to personal property or loss of use of that unit. The statutes don't really speak to this issue at all. And it's possible, I suppose, that an insurance policy of an owner could cover loss of use, but it wouldn't be a responsibility of the association. It would be if the unit owner's insurance covered whatever the issue was, there's a possibility that would cover loss of use or displacement. But generally speaking, the answer is no. The association is not responsible for housing folks who may have to move because of repairs or maintenance. Anything you want to add to that, Ken?
Well, if you've got a situation like this, it might be worth some consultation with an attorney. I can tell you that the city of Issaquah has a city code that requires that if a building owner, which includes the HOA, takes an elevator out of service, that and a person needs an elevator as an accommodation for disability, that the association or building owner has to provide alternative accommodations or an alternative way to get them up and down to their unit.
Mm-hmm.
And so that was an interesting wrinkle to learn for one of our clients.
Yeah.
I would also say we've had clients that have sort of worked out cooperative programs with their owners so that they could stay in each other's units while work was being performed. This actually happened in my parents' building downtown, where the windows were being replaced and the contractors had to come in and disrupt a unit. Well, the building has a lot of units where people are out of town for months at a time. And so they sort of arranged a swap program where for the week that the unit was being trashed by the contractors, they could go and stay in one of their neighbors' units. And it was a cooperative way of solving a problem instead of just telling everybody that they had to be gone.
That's a much nicer response. Very collaborative.
Next question. In the state of Washington, what is the criteria, credentials, education, et cetera, for someone to be a certified community association manager? We're thinking of switching companies and want to make sure we get a legit person. What should we, as a board, be looking for? So first, I'll offer that Washington State has no certification or licensing requirements for managers of community associations. If you wanted to manage an apartment house, you were required to be a licensed real estate agent, but that is not true for the community association industry. There have been efforts to require licensing. The state didn't want to put in more administrative expenses. So the legislature's response is, well, we'll just require you all to be real estate agents as well. The community association industry was not excited about having real estate licenses, so kind of killed that. There is a national organization called Community Association Institute, and they have certifications for not just community association managers, but also reserve study professionals and even lawyers like me. And so typically we would suggest you look for the CAI certifications because there is very little else. Though the Institute for Real Estate Management, which is also a large national organization, they do put out a lot of, I think, certifications for property management, which may have application to our industry. So anything else, Lisa?
I put the link for the CAI national website in the chat, and I also put the link for where you can search for certified folks, professionals in there as well.
Great.
Next question. We are an HOA community. Our board reduced the quorum to 10% a couple of years ago, but never amended the bylaws to reflect this change. Should the bylaws have been amended to reflect the change for it to be legitimate, or does it matter at all? Also, how low can you set the quorum? 1, 5, 0. Generally speaking, if the board changed the quorum requirements from what was in the original governing documents in either the declaration or the bylaws, they probably should be amended to reflect that new information. So if it was in the bylaws, new bylaws should be adopted by the board. If it was in the declaration, you might need an amendment to your declaration. Talk to your association council about that, and frankly about whether you're going to amend your bylaws as well. The Nonprofit Corporations Act does set a quorum for members voting at 10%. So if your documents say nothing, they're already the statute already provides for the quorum that you've changed it to. But you probably want to consult with your council about whether or not you need to make changes, because there may be different quorum approaches for different statutory requirements. And you want to make sure that you're complying and you're not enforcing something that isn't able to be enforced by your governing documents in your statute. Anything you want to add there, Ken? Did I miss something?
Well, this is one where we again
Oh,
get to be really fact specific, and you
That's right.
need to make sure you're following it. And then also remember the priority of the statute. So the nonprofit corporation statute is only going to apply if the homeowner association statute you're under doesn't have something different. So for example, the Condo Act sets the quorum for an owner's meeting at 25%, so you couldn't drop it to 10. The Homeowner Association Act sets a default of 34%, so you couldn't drop it to 10 without an amendment to the bylaws or declaration. And then some of the corporations are under the Miscellaneous and Mutual Nonprofit Corporation Act 24.06 instead of the regular Nonprofit Corporation Act. And that one has a minimum quorum of 25%. So this starts to become really technical in terms of which one of the 5 statutes do I want or need to apply to my question? And then the only other thing is, it is possible under some governing documents for the board of directors alone to modify the bylaws. So there you have to look at your own bylaws, because if it says the board can do an amendment, then the board could just do the amendment, as long as it still complies with the other statutes. But it should have been reflected in the documents. Yes. Next question. Both our current president and treasurer will resign at the end of February, and unfortunately there are no volunteers. If no one is willing to serve on the board, are there consequences for our condo building? We have discussed this multiple times. The short answer is that the members serve until they're replaced under the statutes. And it's pretty easy for everyone until the last board member to resign. But if you're the last one sort of standing, I think you're sort of stuck until you can find and appoint a replacement. And, you know, people talk a lot about how a receiver can be appointed to manage the affairs of the association. And that is true, but a court can only appoint a receiver if there is a lawsuit. And that means somebody has to sue every one of the members of the community. So if you don't have a board member, or, you know, a board member willing to serve, and you're willing to pay an attorney to sue all of your neighbors to force a receiver to be appointed, you could do that, but you're going to spend a lot of money doing it. And if you're willing to spend that amount of money, you might as well just serve on the board instead, because it's much less expensive. And it is, you know, it's possible, and we've seen associations actually become administratively dissolved and have to be resurrected at some point in the future because they finally want to take some action as a group. And then the other thing I guess I would suggest to people is that just because the association got administratively dissolved, it did not eliminate the CC&Rs or the condo declaration. And it may just be that only individual owners then have the power to cause the documents to be enforced. And then the answer might be different if you've got professional management. And I know we've talked before about, if you've got problems getting people to serve, look for ways to make service less of a chore. Hire managers, hire attorneys, hire engineers, hire accountants, hire people to do the work and give advice to the board so that the board's decision-making time can be reduced and they're willing to serve. Anything else, Lisa?
No, I was just going to say that hiring all those folks might end up actually being a lot cheaper than forcing an association into receivership. So I think those are good points.
But you're going to pay the receiver too.
Right, that's right. It's not cheap. Next question. Is there a stipulated requirement in Washington state that a certain percentage of board members must be residents of the building? The short answer is no. There's no statute that says or requires that a board member has to live in the building. There could be, as we've talked about before and earlier in this conversation, requirements for a board member to be an owner, but residency is not been addressed and is not required by the statute. And I think just as a practical matter, if this is, I guess I'd want to know why this question is being asked, or what is causing a concern amongst the owners that people need to be living in the building. I think now with the advent of the Zoom meetings and that kind of thing, it's so much easier to have board meetings. And if you have people who are willing to serve on your board and your documents allow them to serve on the board, take their volunteerism if you can, as long as there's not another underlying issue. Anything to add to that, Ken?
No, I think that's the correct answer, but we do have some clients with qualifications in their bylaws for not just even residency in the community. We have some where they'll state that one board member has to be chosen from each of the buildings within a community. And it starts to become difficult because, you know, you might have a community with 10 buildings and, well, let's make it smaller, 5 buildings, but you don't have a person from each building willing to serve, even though you can fill the board. I do understand some of my clients' concerns that if a person doesn't live in the community, they're not going to understand the experiences that you're trying to address. They're not going to be able to, you know, recognize violations or, you know, deal with hearings. But it is, again, it becomes a potential barrier to service, and statutes don't address it at all. Okay. Next question. With a 210 warranty, which I've learned from Lisa is a type of homeowner warranty that you can get when you purchase a home, does that cover driveway and or parking spaces that are part of a condo built in 2015? So, of course, we don't have the warranty to look at. I would offer a couple of things. One is the 210 is offered by a private company, so it's going to be whatever their contract documents state. Probably it will not cover the common elements of the association because it is not part of the real estate owned exclusively by the purchaser of the warranty. Okay. If the question is, are there any other warranties for a driveway built in 2015? I can offer that there is no statutory warranty of any kind in Washington state that would cover that because there's a hard and fast 6-year statute of repose where you cannot pursue a claim against a construction professional more than 6 years after substantial completion. Anything else, Lisa?
Nope, I think that covers it. Next question. How can I find out if an association is a 501c organization? The question asks about another type of 517, but as Ken and I discussed previously, or between ourselves, that is a religious organization. So I think they may have been asking about a different tax identity. But in any event, if you're trying to find out if your association is a 501c3 organization, maybe you're talking about a 501c4 or a C7, you can certainly ask your accountant, your person who does your taxes. They would have that information. You can also, as I did, you can just Google, how can I find out if an organization is a 501c3, and note that the IRS actually has a search tool that lists, that you can basically plug in the name of your organization or the organization you have a question about, and it will spit out answers of places that match that and whether or not they are so organized. So hopefully that is the answer to the question that you were looking for. Anything you want to add to that, Ken?
Yeah, 501c has a number of different subsets. 501c3 is specifically for charitable organizations, and condos and HOAs are not charitable organizations. So most condos and HOAs are formed under 501c4 or under 501c7. We leave it to the tax professionals to figure out why you'd care about those particular two, but you're not charities, and the contributions you make as a homeowner to pay for association expenses are not going to be a charitable contribution on your tax return. Next question. An association has 5 board positions up for election at their next annual meeting. Terms are for 1 year, and in this association, voting is done by a percent allocation. They have 5 volunteers who will be on the ballot for 5 vacancies. If a majority of the ownership vote for 4 owners on the ballot, but 1 owner does not get a majority of the votes, can the owner still participate on the board? So I guess there's a couple of variations, and some of this again starts to be very specific, and I don't want this all to be legal advice because I don't know the specifics for your community. But one way of them participating, even if they didn't get elected, was for the other board members to appoint him to a vacant position. because under that fact pattern, you would have left one vacancy. Most governing documents do not require that someone receive a majority of the votes to get onto the board. They talk, most are what we might call a plurality, which is whoever gets the most gets the positions. Okay. Sometimes we see bylaws which require you vote for each position one at a time. So for the first position, you might have 5 candidates. The second position, you'd have 4 candidates. The third position, 3, etc. But I also do believe that if a majority of the owners were to specifically vote to exclude a person from the board, that person cannot serve on the board. And so, again, very fact specific. I don't think a person is entitled to serve on the board just because they volunteer if no one else wants them, but it will depend on how the election process, I guess, takes place. Any other thoughts, Lisa?
Nope, I think that covers it. Next question. When an association owns units and the bylaws do not address voting rights or procedures for the association-owned units, how are those units treated in an ownership vote for something like special assessments? So the statutes were all amended and they all point out that, and an association is, if the association is the owner, they are an owner entitled to vote, but their vote cannot be the deciding factor or the deciding outcome of an election. So if, as Ken discussed with me previously, if there were 20 units, or I guess, I don't know. Anyway, if there's an even vote with the other remaining units and the association was going to be the tiebreaker, they would have to give half their vote basically to each side of that vote. Their vote could not be the one that pushed an agenda or a budget ratification or whatever it is over the deciding to be the deciding factor in the end result of that vote. So they do get to vote as a regular owner, but their vote is not to be the deciding factor or the deciding outcome of that election. And they would be cast in the same proportion as any other owner. So whatever the ownership interest of that unit is would be voted just like any other election. I think that, probably if there's more technical conversations about how they would do that vote. But I think the question is, can they vote and how does that work? And the answer is yes, they can, but they can't affect the outcome of the election. Anything I missed there, Ken?
I just, I'll give a cite for 6432-280. It's subsection 9. It is subsection 9 in the voting section of the statute for every one of the 4 statutes we use. So I think that it can qualify as bringing you to a quorum if you needed a quorum, but it's not going to affect the outcome because the statute says it must be cast in the same proportion as all the other votes cast. Right. So that's a change that took effect for every community in 2021, I think it was. Next question. Can bylaws be amended for board members to be required to take courses to get board member certification within 90 days of being elected? And if they don't do that, can they be suspended until they get that? There's a bunch more about why they think board members should be certified. And I think that it certainly there's a possibility, at least in theory, to amend the qualifications for your board members to require specific education. I don't think it's a good idea personally, because I think that if you were to try and set up this additional barrier, you're going to cause a lot of people to decline or back off of serving on boards. The legislature is currently looking at a minimal requirement for board members to learn about fair housing, which is to prevent discrimination. That is not the same as trying to require an owner to do an 8-hour day of training through CAI in order to be certified about becoming a board member. I am all for education and I promote it, and I think it'd be nice if board members would become certified. But I think that it's going to be an enormous barrier to the getting representation on your boards from membership. So, Lisa, do you have thoughts on that?
No, I was just gonna point out that sometimes we will help associations do things like a board boot camp or provide training. So that may be an option if you're trying to make sure that a board understands what their role is. That may be an option where you have a captive audience instead of putting it into your documents.
Yeah, we also at least used to see management companies have annual training for all of their boards, because we used to be invited to come and speak at those. That kind of got killed off by the pandemic. But, that would be, I guess, what I would do is try and encourage your boards to participate as a group in training sessions for the areas you feel they need. So if it's maintenance of the buildings, then, bring in someone, an architect, engineer, someone who understands buildings to help them better understand. If it's, you're worried about budgeting, then your manager or accountant might be able to help. If it's enforcement, managers or an attorney might be able to help. So, but
Yeah, we
I
also
think that,
yeah.
that would be my preferred, instead of trying to make a certification requirement and then throw them off the board if they didn't meet it.
Yeah, I was just going to add, there are a lot of educational opportunities with the local chapter of the WSCAI and participating in things like the online discussion groups with the national organization as well. Let's see, next question. Has anyone successfully allocated costs for increased premiums for HOA master insurance solely due to exceeding the carrier's rental percentage cap onto the owners of the units being rented by way of board action, as opposed to a vote of all owners? Many of the documents do allow you to allocate insurance costs based on risk. It depends probably on your specific documents. But if there is can point out like a childcare facility or something, some kind of a business in a unit or lot that affects the risk of the association, you may be able to allocate certain percentages of the insurance cost to that risk. However, I don't think you can do it. Well, Kim, maybe you can assist with this. What is the timing of that? Are you doing it as, let's say someone puts a childcare business in their home, and can you automatically start charging them for the change in insurance assessment?
Well, that's a question that the legislature provided for and we've never addressed yet.
Okay.
Kind of getting back, have we seen an association successfully allocate increased insurance premiums to the landlords? I can say
Sure.
I have never seen it, but it may be happening in the management company's bookkeeping office and I don't see it.
Mhm.
It would require first that you actually have a precise number from the insurance company on how much of their premium was specifically due to the increased number of rentals, and covering just that risk, not covering those units, but just that particular risk. So theoretically, it could be done. I think in a practical sense, it would be really challenging to do, and you'd probably be talking relatively small dollars. Dollars so small it would not make the administrative burden worthwhile. Next question. Has anyone included a mortgagee in voting with unit owners for amendments to governing documents? Short answer is yes. We try and avoid having to do that by writing our amendments to not affect mortgagee rights, but we have certainly participated with clients where they've gone out to do it. If you're a a new act condo or a Ukiah condo, you have the benefit of only having to get the votes from eligible mortgagees. And most mortgagees or lenders do not identify themselves as a bank that needs to be contacted. So it makes it much easier. But old act condos and HOAs, we have, yes, participated where every bank had to be found and contacted. Anything else, Lisa?
Not on that question. Next question, any advice on how to implement a rental cap for a small association already exceeding their carrier's rental percentage cap when no votes from the owners renting their units leaves the yes votes short of the 67% required to pass the rental cap? I think the short answer is that under Kiowa, you can't apply the rental cap to an owner who is in ownership at the time of adoption, or any particular restriction on the use of their unit. So you would need to propose a rental cap that is prospective in nature, so that it affects unit owners on the next go round, after the sale of their unit. I think that would be if it's sort of a not my problem vote. They may be more interested in supporting it, but I think, because you are trying to affect an owner's use of their property, it needs to apply to the next owner of the unit. Not sure if that answered that question at all. Ken, do that anything to add?
Lisa's trying very hard to avoid the politically incorrect term of grandfathering the
Yeah.
owners. But that is the way we have seen communities do it.
Yeah.
Is a lot of landlords are happy to vote for it as long as it doesn't affect them, because they do recognize that it is likely to increase the sale value of their unit when they decide to sell.
Right.
And our last question in advance is, do we have any experience with rounding vote percentages so that 4 of 6 votes could be considered 67%, the number required by the statute or by their governing documents? And my shorter answer is you cannot round. Is that if your percentage is 66.66%, that is not enough to meet the statutory or document requirements of 67%. And part of my answer is that the legislature could have easily said 2/3 as the minimum instead of 67%, and they didn't do that. I've also had a situation with an old act condominium where a majority is defined in the statute as 51%. And so we had a client where the approval vote was 50.7%, and they wanted to say it was a majority. And it would have been a majority, except that the term was defined in the statute that controlled their community as being 51%. So I had to advise them to go find another vote to get up to the 51% instead of trying to pretend they had reached it. So anything else on that, Lisa?
Nope. Chelsea, do we have any questions in the chat?
There was a follow-up question to what you just said, saying, so how do you handle that 67.7%?
So for the most part, we tell them get the extra vote so you can get to 67%. Ukiah has some interesting provisions which relate to small communities. And so it might be possible if you were a 3-unit condominium under Ukiah to pass with a 2/3, even though you didn't get the 67%, just because they wrote in provisions to try and prevent a single owner from stopping the rest of the community from taking action, which they wanted to do. So if you've got a question about that and it's a Ukiah community, we can certainly delve into that statute. Otherwise, the answer really comes down to you need to persuade more people to participate, or you need to persuade them to change their vote. And we've certainly seen negotiations on specific terms of amendments that were done in order to get an additional vote. You know, I've had, you know, we do a fair number of rewriting documents, which have a lot of new terms. And one of the ones we often will put in is an arbitration provision to try and streamline dispute resolution. And every once in a while, we'll get a community where there are members who are absolutely unwilling to vote for something if they lose their right to go to court. And so we will find that out and we'll delete the arbitration provision so that they're willing to support the rest of the document. We certainly have seen rental cap provisions where there is negotiation through the voting process to adjust the number of rentals to reach a number that the necessary majority of the owners were willing to support. And it may mean you have to vote a second or third time, because if someone voted for a rental cap of 11 and you've changed the cap to 12, they have to approve that change as well. You can't just still count that as a positive vote. Hopefully that helps.
All
Any
right.
other-
Anything else? Jessica?
Yes, so we have, when payments are made on delinquent assessments, are payments first applied to the delinquent monthly assessments, then the administrative fees, legal, late, etc., or just the total amount due? If applied to the total amount due, how does the association later determine what balance is attributed to actual delinquent monthly assessments versus legal and administrative fees prior to a foreclosure notice?
This is a pretty technical question. Some of it depends on the collection policies, rules, governing documents for your association. That being said, if we're talking generally and we're talking about the new foreclosure statute, and we're looking holistically at a ledger, we'll generally look at it to determine if an owner is ripe, I suppose is the right word, is a word you could use for foreclosure, is how much have they paid and how much are the assessments? Because if those numbers don't, so ignoring all the other costs and charges on the account, if they've paid more than the amount of the assessments, then they would likely not be eligible to be the subject of a foreclosure lawsuit. But like I said before, this is a pretty technical question that I'd hesitate to give very specific response to, because there are a lot of things, balls in the air. I would certainly talk to your association counsel and make sure that you're all on the same page about what's been paid, what is owed, and what are technically assessments. Anything to add to that, Ken?
Well, just you do need to check your governing documents. There is an attorney who did a lot of amendments for collections, who wrote very specifically that his law firm was supposed to be paid first out of any receipts. And I think it was absolutely the wrong thing for him to have done. I might have even considered it unethical, but it is the priority of application, and that means you have to be looking at it when you try and figure out how much the owner owes.
That's right. Yeah.
But I'd also, I guess, say I would rather have a client delay a couple months of foreclosure action if there's a question, because if you're just barely on the borderline of that $2,000 threshold, I don't want to have to be arguing with a judge about what the legislative intent was.
Exactly right.
The next question, I live in a small condo community, 8 units, and no one is volunteering for the HOA board. Can we mandate all owners to participate as board members?
So I'll give it a shot. I have a number of communities where every unit owner is automatically on the board. That can be good and bad, because it means you've always got boards, but it doesn't mean you're ever going to get a quorum, because if you've got a board of 8 and you need to have 4 to reach a quorum and they won't participate, then you don't get any improvement to your situation. I have seen clients write in requirements to serve on the board. It also has the problem of putting people on the board that you may not want on the board, who are going to just, veto every expenditure because they just don't want to spend money. So, I don't think that's the solution to the problem. Lisa, do you have thoughts?
I was just thinking if you're already having problems with people stepping up to the board, you may have issues getting people to agree to those kind of changes to the governing documents as well. But yeah, there may be other options to get people involved. Like we talked about earlier in the conversation. Anything else, Chelsea?
No, I think we're good.
Okay. Well, thank you everyone for your attendance today, and we'll see people next week.
Bye.